Dear friends, this video is on the landmark judgment for home buyers or those stalled projects by the Hon'ble NCLAT. The three-member bench headed by Honorable Justice Rakesh Kumar Jain, judicial member, passed a landmark order. And this is aligning with the views of Honorable Chief Justice of India, Justice Bhushan Gavai, and Honorable Justice Surikant of Honorable Supreme Court. Recently, both of them, one in London conference, Honorable Chief Justice of India, and the other one, and other Honorable Judge in Singapore conference, they emphasized the required approach for commercial litigation from the traditional adjudication, where interpretation of law. The judiciary, finally, the job of judiciary as per the constitution is to focus on the interpretation of the laws. But then how do you interpret? That is where a beautiful analysis, a short form. This is a judgment in Lotus Apartment Owners Association delivered by the Honorable NCLAT, which is in aligning with that. Now, what did our Lordship's Chief Justice of India say? Let us see before going to the details of the case. Need for commercial sensitivity in litigation. Honorable Bhushan Ramakrishna Gavai. There is a need for commercial sensitivity in litigation. And courts must differentiate commercial disputes from traditional civil or criminal litigation. The judicial role is not just to interpret the law, but to secure equitable outcomes in complex economic contexts. That's what he said in London. Emphasize the urgent need for Indian courts to approach the commercial disputes with a distinct lens, balancing legal interpretation with commercial sensibility. Honorable Justice Surikant echoed the same sentiment towards the pragmatic commercial jurisprudence. That's a new word used. Rigid legal interpretation must give way to practical problem solving, especially in the commercial matters where delay equals decay. Beautiful word. Delay equals delay. The coining of the word is really apt for this particular insolvency and bankruptcy code. Speaking at this conference, he reiterated this modern outlook, urging judges to be facilitators of real-world solutions, not just keepers of statute books. Now, we are trying to align with this. The Honorable Justice Rakesh Kumar Jain sir and the other two technical members, they analyze this because there is a great problem. The home buyers, middle class mostly, investing their life savings and the belief the gullible promoters, builders, landlords, and then get stuck up for years, having lost their hope. And this is the judgment which gives oxygen to that. The project started in 2010, had 4 towers fully completed. Factual matrix. Towers 5 and 6 were nearly done. Despite full payment by allottees, the builder diverted funds elsewhere, estimated siphoned amount 190 crores and halted the project. IndusInd Bank sanctioned 33 crore loan in 2017 and declared it as a non-performing asset in 25 and filed for CIRP. Now, the issues for adjudication before this honorable bench. Can the association complete the project, keeping in CIRP admission in abeyance, bypassing the resolution profession? This is the issue. That is, the association says, we will invest our money, we'll get it completed. Endless litigation. This is 2010, means 15 long years have gone by. There is no solution, litigation. So IRP is another headache, is a cost. So we don't want IRP. We will complete the construction. This is what everybody says. Honorable NCLT Chennai bench, NCLT Chennai bench, when liquidated the same issue, they said beautifully that it is because of the insolvency professional you are all together. How did you come here? It's because of him. And that's because that insolvency professional is because of the IBC. Therefore, you cannot bypass the resolution professional who is a court officer. It is for your good only. Can NCLAT direct the corporate debtor and RP to facilitate registration of individual sale deeds for home buyers? That is the issue. Very critical issue. Moratorium and exclusive powers of RP. NCLAT confirmed that once CIRP is admitted under Section 7, the moratorium under Section 14 is in full force. All powers to manage operations, including project completion, vest exclusively with RP. No third party can bypass RP without his nod pending resolution. So the law, the IBC legislation itself, the pivotal person, the anchor for the entire process is resolution professional. So then if you are going to remove it, it's like a garland that will be in the hands of monkeys. So that is how the same thing what they have decided. While recognizing the contractual rights of home buyers, NCLAT held the rights do not override CRP mechanics. The process doesn't cease because of external parties wish to complete the project. Beautiful. And the NCLAT acknowledged the hardship of buyers unable to get sale deeds. It directed the RP and corporate debtor to cooperate with Noida Authority and Association to facilitate the registration. This includes providing necessary documents and pursuing the completion certificate NOC through standard channels, all under the supervision of RP. Conclusions. The association cannot independently complete the project or assume the control while insolvency proceedings are active. However, RP is directed to collaborate. See, the balancing. Honorable Justice Rakesh Kumar Jain is a very good listener, calm, and very knowledgeable. You can raise questions, pointed questions in the process of hearing. And within the four corners of law, at the same time facilitating the process. That is how many of his judgment, Byju's also has come. Collaborate with the Association, Noida Authority, Architects, Fire and Safety Officer, Structural Engineers. In other words, the active role of association is encouraged because they are going to fund, and unless they get confidence that they will get the houses, already they have burned their fingers, then why do they come? So these NCLT proceedings will assure them that there is somebody to protect their interest through the medium of RP. So ultimately it is these people who will invest money and then ensure the houses are 15-year-old house unconstructed. It may be in a weak condition, building structure. Facilitate completion documents and certificate. Ensures timely registration of sale deeds via usual statutory procedure. Here RP will be a facilitator. That is what is the law envisages. And without saying detailedly, without refusing anything, they blended all these issues. That is called as commercial litigation adjudication. Summary. CIRP moratorium cannot be set aside. Only the RP manages project operations during IBC proceedings. NCLAT did not allow the association to self-complete the project, but did direct RP to actively facilitate the milestone closures and registrations. His balanced approach preserves IBC integrity while safeguarding home buyers' rights to register the ownership. That's the law. Now, friends, this is NCLT Chennai bench where we have been actively associated appearing. There is a problem. 2017, this law came into force, IBC. Till 2023, then home buyers were also made financial creditors. They were given some voting rights and all. So many IBBA started coming out with this. But then no movement. And several projects which we were involved, I was involved, is found that we can't blame NCLT Chennai bench during this 2017 to 23. The law is evolving. And they, as you know, repeated, reasserted by the Hon'ble Chief Justice of India, that power of deciding needed in interpreting process. But then they were new law, no? They were following interpretation, top lawyers appearing and all. So we had adjudicating culture. In this one case, 80 times it was adjourned during this period. Then the promoters will be going to NCLAT, RERA, here, there. We introduce people, file cases. Lack of coordinated legal understanding. Home were caught in the web of adjournments and legal delays. Investment deadlocked. Lost trust. Nobody ever thought they will get the houses. Escalating rent, EMIs, and mental trauma. Unbelievable, because they are all middle class people. Now came in 2003, 23, the benches have changed. New judges new members have taken over. This bench 2, judicial member, Honorable Jyoti Kumar Tripathi, Ravichandran Ramaswamy, technical member, and Sanjeev Jain, sir, and judicial member Venkatam. This is the combination, because benches keep, rotate. One time this judge will come, that judge will adjudicate. But their focus was very clear. And I felt, because I've been watching, that they felt this needs a different adjudication. And you can see, shift from procedural to solution-driven approach. The benches began monitoring the implementation. Real focus. You need houses, that's all. Anything that contributes to fulfilling the dreams of these buyers, we are ready. At the same time, the process, the legal thing has not been disturbed. That is where I felt, which now the Honorable Chief Justice was telling. Ecosystem realigned. Promoters, buyers, RP lenders, everybody is taken care. But then active participation of adjudicating authorities made all things possible. And then today, I think more than 2,500 home buyers, almost many of them have taken possession. Here what happened, they formed associations, and through that associations, money, whatever is spent is leave it. Whatever more you have to spend, decide. And all that maybe 5 to 10 lakhs you have to spend. You can complete and you get a house worth 1 crore. Not only that, the builder might be having unsold apartments. Those also completed, they can be sold and they get back their already investment compensation also. But then the way in which they facilitated is remarkable. The current market value, and everybody, home buyers we are seeing, they were so happy. They said we invested and now we got back thanks to the honorable judges and all. And then you can make sure Sanjeev Jain sir in one is taking 65 amenities promised. Make sure all the 65 have to be complied with by the promoters. Because one problem here is the ecosystem should not be disturbed, because RP, any time he will come, he may be doing more paperwork. But then who will build? The technology, knowledge, and engineers, and all those. If they start, one is they do. If they don't do and you do, you can't do, then the problem will be aggravated. That is what has been analyzed by this bench. And that is ultimately the results have come. And Supreme Court's viewpoint, I am further saying, courts must evolve from being passive adjudicators to active problem solvers in commercial matters. Justice B.R. Gawai, Supreme Court of India, said, Supreme Court has repeatedly emphasized the need for purposive, pragmatic, and time-bound disposal of commercial cases. Especially under IBC, the objective is revival, maximization of value, and balance of stakeholders' interests, not just procedural ones. Honorable NCLAT and Chennai bench, NCLT has operationalized this vision through its approach to stalled real estate projects. No longer limited to mechanical interpretation, instead the bench applies contextual, equitable, and stakeholder-centric approach. Now, what is the guiding principle of Supreme Court, Honorable Supreme Court? It is implemented. Justice must be substantive, not just procedural. Courts should aim at real-world impact and promote commercial sense over technicalities. Judges must be solution-oriented. Everything is achieved. So thanks to the insolvency starting, so my point is that this we are presenting to the Honorable Chief Justice of India, Honorable Supreme Court, to explain that this particular is a case study. What lordships have said in the London conference as well as in Singapore conference is a abstract, in general terminology. But how it should be facilitated is what I have analyzed. And thank you, dear friends. I humbly request the colleges to subscribe to this. It's reaching almost 1,000 colleges. And thank you very much.